introduce Margaret Briffa, who runs Briffa legal practice, intellectual property lawyer. And actually really well known in this area. Margaret set up her business in 1995. So you're going to talk about the Trunki case study. Thank you, Margaret.
Mentioning things like that. This is the heading that Hayley gave me, how not to be foxed by it, but I'm foxed on a daily basis. So anyway, we're here to demystify everything. Now, in my business, we deal with a lot of small businesses, and we've got this mantra. What we're trying to do is trying to identify what people have, protect it, make sure they're dealing with it well on a commercial basis, and then enforcing it. So if someone comes too close, obviously you've got to stop them. Now, why are we doing that? We're doing it because if you can be bothered with all this, it's actually worth a lot of money. It's worth money while you're dealing with your business and while you're actually in it, but it's also worth money in the outside world if you want to sell it. It is a really good asset. So what I want to do is give you an example of a client who made money, to get you all encouraged that it's all possible in your businesses. And while you're listening to Hayley, you're all scribbling down like mad, presumably writing all the different bits and pieces of IP that you have. Okay, so this is Tim's tale, Tim Answell, who was a client, and he didn't go to university or anything like that. Sort of 16, he took to his bedroom and started writing computer games. I don't know if anyone knows this series of games. No? Do you look like people who waste time playing computer games? No. Okay, so he had a great interest in history and coding. So he started on his own, as I say, he went off to his bedroom and started developing. Was joined by one or two other young men, and they got a contract with a publisher. And the way that it worked was the publisher said to them, here's £100,000, write me a game, sign this piece of paper. So they signed a piece, £100,000, wow. You know, so they signed a piece of paper, and they're going to get the money in stages. Now, that piece of paper, as it turns out, just assigned all the rights. But we don't know that because we haven't met Tim yet. But what happens is one of the other boys in the bedroom decides to go and set up his own thing. They have a disagreement. So that's when we actually meet Tim. He comes to see us to say, what can I do? Someone's run off with a bit of code and everything. Now, code is a copyright work, so there's stuff that we can do. We can contain that, get it under control. But now we've got Tim because he's come to see us. He doesn't have this holistic plan that everyone's been talking about that you all need to get together. And we say to him, look, Tim, the way you're doing these contracts is not right. You know, you're just signing everything away and getting the money, and that's great, cash, and you're buying yourself bits and pieces. But you don't have a plan, and you need to have a plan. So the first thing you're going to do, that next contract, you're going to tell them you're not signing it, and you're only going to give them exactly what they need, which is the right to publish the game. They don't need anything else. They don't need the marks, all the other IP and everything. So we're going to cut that down. He said, I can't do that. They won't sign. But they did. Why? I mean, in this case, he's proven he can deliver a game that they want. So the first thing is we fixed his contracts. Then we started looking at all the other IP, trademarks. Who's getting them? The publisher wasn't, he wasn't, so we get them. Patents, some of it was very, very clever stuff. So we sent him off to a patent attorney to get some patents for, you know, on the artificial intelligence scene. The database, you know, there were fans, had a fan site, there was a huge amount of data there. I mean, data is a bit underrated, but it's becoming more and more valuable that you're collecting data and you're collecting it in the right way. And then we started fixing the things internally, like did the developers that he'd employed have a contract? Would they just go off to competitors with secrets and code and all the rest of it? So we fixed that as well. And then going along, we were dealing with infringements on trademarks. The game started being counterfeited in the Far East, so getting people involved to stop that. And then we started using stuff that he'd already developed to make money out of it. This is commercialising your rights. So he had the code. Where else could we use it? Sold it to a mobile phone company. Also sold it to the BBC too to make this programme that was on in the sort of early afternoon. Again, you don't look like sort of people who watch this sort of thing. But literally it was a screen with the game on with 2 teams. And we got extra money for no extra work, just because we could reuse the code and give the BBC a license to use it. Anyway, okay, I said that in just a few minutes, but that's over a number of years, okay? You're working over a number of years, you know, carefully making sure, having some, you know, they have a sounding board that they can use and say, this has happened, that's happened, what now, and steering it, but there is a plan. So he gets a telephone call from Sega. They're very interested in buying the business, and of course Tim's very flattered and says great, 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 and they say, you know, £600,000. Yeah. So he rings me up and he says, this has happened. I said, stop, do not do anything else. They clearly don't know that you have the intellectual property in this. They just think you're a developer with a random bunch of people. And that was right. I mean, that's what he got for it in the end. I also collect rather dubious newspaper cuttings. Oh, right. He got featured in The Sun because Tim was quite a sort of shy person who always felt because he didn't have sort of university education and everything, it was never going to work out. And The Sun loved this story about him being able to sell to Sega. When they found out, they did due diligence and they found out that he had the IP portfolio, they upped the price to that. Okay, this is what you've all come to hear about. Something else rather foxing. The Trunki tale, that's Rob Law, owner of Trunki. Does everyone know about these little suitcases? Has not everyone been tripped up by one? I have. Oh, bam, they're very Trunki again. Okay, this is a picture of Rob with one of his really successful products just before bad things started to happen. But let me give you a little bit of history, because we probably met Rob in about 2006. You see, if you're all at a reasonably early stage, it's very, very good, because, holistic, we're going to have to keep bashing on about this word today. Holistic advice is what you want, and ongoing advice, because, just to say very briefly, a lot of people think, I'll put off that legal thing until I get money or I'm a bit further on. And that's a big, big mistake. The earlier you speak to, Innovate or anyone else who can help you on your journey, the better. Some things are rescuable, but some things are not. And I know you're going to hear from a patent attorney later on. And patents are not rescuable. So, it's good to think about things and think about it early. But just getting back to Rob, in about 1997, which is now more than 20 years ago, and I always think of Rob as really young, he was a product design student at Northampton University, and this was his final year project. He decided that he was looking around for children's luggage to enter a competition run by the Institute of Material Design. Now, has that changed its name to the Institute of Plastics? Is that the same? That's the same. It's the Institute of Plastics now, but it's anyway. He entered this competition. So he entered the competition in 1998, and he was one of 6 shortlisted, and he actually won the prize with this thing called a rodeo. The feature, you can see that this is going to be relevant later, believe me, this rodeo. We knew nothing about the rodeo when we met Rob, but just bear in mind because it is going to be relevant. Anyway, he won it, and it went on the Institute of Materials website where he was featured, literally like this in front of the rodeo, and that's it. Bear that in mind because that would, as I say, is going to be relevant. Then what happens, just to go from 1998 to the early 2000s, is he carries on developing, having won this prize, he gets mentoring and he carries on developing this suitcase, and what he does is he goes to the toy fair in sort of 2001 and hooks up with a business called Toyline and gives them a license to manufacture and sell his thing. Unfortunately, they don't last very long, but he's carrying on refining it, and he actually then files this design. So this is an actual image of what he filed in June 2003. Okay, so his understanding about registered designs, and that's very good. And there's a lot of help on the European Office website, which helps you file, and this is what he actually did. Now, in 2006, he goes on Dragon's Den. Do you remember? Does anyone know this guy? And gets completely slated. That's completely rubbish. That's never going to work. But he carries on working. What he decides after the manufacturer, the licensee goes bust, is that he will make the thing himself initially in China. And these are drawings. He's a proper product designer. He's keeping very good records and images of everything he's doing. Okay. So here's the bad thing. As I say, we met him in about 2006 and helped him with other things in his business, including infringements. But in 2011, we find this on eBay. This is something called a kiddie case. I'm sorry if the image isn't very good, but you can see it's the same. It's similar. It's just, immediately you see it, you probably think it's different, but hey ho, there's something wrong with that. So he comes to see us, and we say this is looking potentially very serious. I'll just do the next slide first. We find that the goods are being imported by a company called PMS. So we're trying to gauge at this stage how serious or not it is, and whether we're going to need to do something. And this is what we find out very briefly, is that, they're a whole group basically. They've got offices in Hong Kong, they've got factories in China, they've got massive amount of warehouse space. They've got 10,000 product line, okay? They like to pick sort of products that are doing very, very well and make something similar. They've got a UK turnover of 36 million at this time, but they're paying tax on about $500,000. And they've got a holding company in the Caymans. So, that just to us looks dodgy all over. And very difficult opponent. That's what you've got to be aware. You've got someone very difficult to deal with here. I just want to go. How do I go back? Oh no.
Oh no.
Oh, no.
This is
Oh no.
oh, the sound works. Yeah. Yeah.
Have you got it? No.
That's another Loughborough design product.
There we go. This one.
Just want to go back to the first. That one, yeah.
No,
Okay.
So back is that one.
Okay, sorry.
It's all right.
Sorry. So that's what we know about our potential opponent. But what about us? How serious it is for us? Because at this point we're thinking, do we need to apply to the court for what we call an urgent injunction? That means that we can't wait, a year for the decision. We've got to get it stopped now. So we're a one-product company, or we've got one other product, but it's not really doing that well. So 65% of all our revenues are coming from this company. We're doing very well with it. We've got 20% of all 3 to 6-year-olds owning one of these things. And the year before we discover this, we take on a factory in the UK, because we moved our production from China to the UK. Then the factory that we were using went into liquidation, so we took it on. So we're also now sort of an employer in the region. So we send a letter. This is the normal thing that happens. You send a letter to the other side saying, this is really serious, it's an infringement, you've got to stop, or else. And they say, get stuffed. We've got, well, it's not, that's my dyscalculia. We've got 250,000 of these on the water, and we're just going to carry on. So that is really serious. So we have to do something about it, and we have to apply to the court for an injunction. So that's what we did. So we went very quickly to the court and said, please stop this. It's a design infringement. It's a passing off. We need an urgent result, because if we don't get that, it's going to destroy our whole business, because he's bringing in 250,000 of these products. And the judge said, I won't give you an injunction, but if you drop all arguments about passing off and just go on the design, I'll give you something called a speedy trial. Speedy for a judge means I'll give you a trial in 6 months' time. Okay, that's judge talk. So off we went. The reason why he did that is I think he was concerned for us to do it this cross-undertaking in damages. Because when you say to the court, I need a result and I need it now and really quickly, you can get it if you can show irreparable harm. But you have to be able to say to the court, if you're wrong, judge, we will obviously compensate the other side. So that's a huge risk for a small company. So I think he wanted to not put us under that sort of pressure. Now, when we get to this speedy trial, things go well. So the judge at first instance says yes, the registered design, the thing that I showed you earlier, is clearly for the shape of the case. And the comparison is between the shape of your case and the shape of the kiddie case. And I'm just ignoring the surface decoration. That's what he said. Then then we have to deal with the rodeo. Now the rodeo is something that came up while preparing for speedy trial. So we knew that's not something we knew about. And what the other side said was that rodeo invalidated our design. It was too similar to the design that we'd put in. And the judge didn't agree that, although he did agree that the rodeo was a public disclosure, and that's relevant, because what that meant is that the design formed part of the background, if you like, the general prior art. But despite the rodeo, he said, if there had been no rodeo, I have no hesitation in saying that the kiddie case infringes the Trunki. It's a more difficult question because of the rodeo. Because what the rodeo did, it narrows the scope of the registered design. Okay? It's not like you've got a complete blank, and then out of completely nowhere you get the Trunki. There was the rodeo that preceded it. So the rights in the Trunki are broad, the judge says, but limited because of the rodeo. But he said, despite that, despite the rodeo, I still find there to be an infringement.
No, it's just
you got a question?
No, a few minutes.
Oh, 3 minutes. Cool, right, okay. Right, quick.
I've got lots of questions. But
Sorry. Okay, so these are the actual pictures that were attached to the judgment from different angles, showing the registered design, an actual product, an actual Trunki in this. The colour, the fact they're in black and white or grayscale, irrelevant. Just ignore that. And you're looking at it from all angles, side, from the front. And this, right, okay, 2 more slides. Court of Appeal. So the appeal was on the basis, is surface decoration relevant at all, where you've got this shape design. The Court of Appeal reversed the decision of the High Court and said, no, the judge has completely got it wrong. The judge has failed, this is why law is very foxing, he said the judge has failed to appreciate that the registered design is for a horned animal. And the fact, we know this, it is a horned animal, and that's reinforced by the absence of decoration on the CRD. I mean, yeah? And then a really, really fatal blow for so many registered designs out there. The judge has failed to take account of the fact that it's a grayscale thing. So he didn't look at the different contrasts. If you think back to the registered design, we had black wheels and a grey body and other black bits. So he said when you're comparing that to the kiddie case, you've got to take that into account. Okay. Now that was quite surprising to very many people, including the Intellectual Property Office, who intervened to appeal again. To appeal to the higher court, you need leave. That's quite difficult to get, but with the support of the Intellectual Property Office and other organisations like ACID, who Nick may talk about a bit later on, were able to get leave. And we went up to this Supreme Court, also asking that, you know, that really it should be referred to Europe, talking about European rights here. But they agreed with the Court of Appeal. They completely glossed over the question of surface decoration and whether you needed to take it into account. They completely went with the idea that it's grayscale and the judge had missed that. So the lesson we learn is that we must file line drawings and not CAD images, because they limit your right. That's the biggest thing we've learnt from this whole case. But you can obviously file lots of line drawings on the same day and get different designs. But anything else, photographs, CAD drawings, you know, other images with your hand stuck in the side, all of that, don't do it. And you can do line drawings. You don't need a draftsman, but that's the thing. Now, because I know I'm going to get another one of those clocks flashed at me. All of this was hugely disappointing and to Rob and everything, but he is doing very well, and the business has grown. It's got lots of international sales, and I have actually looked for the kiddie case recently. And there are some images around, and you can find them, but they all say out of stock. So it was that 250,000 products, and it was only that. And after that, PMS didn't repeat or make it again. So it is sort of a victory of sorts, but you don't get it in the way that you think you're going to get it.
Brilliant.
And that's it.
Thank you, Rob.
Okay.